Ladies and gentlemen, welcome to this panel, which is about data protection in the post-COVID era. The introduction has been done. What we are talking about may need a little bit of highlighting or explanation. Let me do that now. What we are doing now is we are trying to explain how this COVID situation reflects in the digital field. With the COVID-19 pandemic raging globally, governments are rushing for innovative solutions to contain the virus. Newly developed contact tracing apps have emerged in several countries, and it begs the question, are they safe? Should they be voluntary? When should those be dismantled? The lines are blurred, and with international experts on board, the panel will discuss all the ambiguities regarding data protection today and in the future. So to put everything in context, let's start from shaping a safer digital future, a new strategy for a new decade. The European Data Protection Strategy for 2020-2024. And for this, let me quote Mr. WIEWIÓROWSKI. I hope I pronounce your name properly. Welcome in the panel anyway. Because you have a couple of thoughts. You have a couple of thoughts that I really want to share with the panel to set the scene for your intervention. Technological advances occurring thanks to human ingenuity and ability to derive insights from experience are nowadays particularly driven by personal data. Companies that have exploited these technologies have become the most valuable in the world, dominating not only their respective markets, but also global information flows. Consumer choice is now very restricted, and popular services have often not been designed in compliance with the EU legal framework in mind. Governments are also keen to exploit the technologies that promise innovation, efficiency, and that are cost-effective. At the same time, technologies designed to increase convenience and prosperity, from behavioral targeting to facial recognition, now enable authoritarian states to strengthen and export their self-serving model of surveillance, repression, and censorship. So, the first question to you is quite related to this. What is contact tracing from data protection perspective, and how does it fit with the GDPR and the European Data Protection Strategy? Please.
Good afternoon from Brussels. Well, let me first thank for the invitation to this panel and to this event, which is extremely important for me, not only because I share this panel with my friend Attila PÉTERFALVI, whom I was cooperating with as a data protection authority, with him and with his predecessor, András Jori, as well, from Hungary. And that's also because this is organized at the center which is named after József Ontol. And József Ontol is an important person for Europe. When I look from my window, I can see the building of the European Parliament, which is named after József Ontol. And I also remember his father, who was an important person for Poles, for my country of origin. For us, that's the name which means to be brave at the time when such a strange examination comes to us. Contact tracing apps, contact tracing is a part of the fight with COVID that we try to do with the use of the IT technologies. And we have to remember that IT technologies and the contact tracing apps are not the silver bullet, and they are the part of much bigger efforts that we try as society and as public authorities to fight the pandemic. Contact tracing is the part of the surveillance actions. One of the things which we have to learn, surveillance, which for us, for data protection commissioners, is something that we are afraid of, that we say that is scary for the society. In the fight with epidemics, it's simply a tool, one of the tools to be used. So we are able, in using the contact tracing solutions, to find out who had a contact with the person who was infected, and who then should take a special care of his situation, his health, and the contacts he had with other persons in the society. Contact tracing is mainly done manually by the people who are prepared for that, who are trained to do that, and who are taking care in the public health actions against COVID. But the tool that was invented in many countries was the contact tracing app, which using different technologies, but first of all, and most commonly, so-called Bluetooth low energy technologies, in order to track the contacts between the persons who were infected or the persons who are around them. That allows us to be a little bit behind, to look beyond the spread of the virus, and allows us to get to know who, as I said, have to take care of himself or herself. By using this kind of technologies, this kind of apps, the persons can get to know that they were in the close proximity or in the contact with the person who was infected. That is done anonymously as possible. So not revealing the name of the person, nor the identity of the person who was infected, but just informing us that we've been in the close proximity to such person. In most of the applications which are in use, especially those in Europe, it's, as I said, done through Bluetooth low energy technology, not through the telecommunication data or other localization data that can be also gathered. So this is one of the ways to help to monitor and to track the spread of the virus.
Thank you very much. You mentioned a lot of very important things, but how does the European data protection strategy address contact tracing? What's our strategic approach to this? Can you please describe?
Well, the strategy which you are talking about is the strategy of the European Data Protection Supervisor. This is not the strategy of whole Europe towards the new technologies, but at the same time, Europe is preparing such a strategy on the use of new tools, especially those that are connected with the artificial intelligence for the future. And bearing in mind that such a solution, like the contact tracing app, is introduced at the time of the special situation that we have in Europe, special security situation that we have in Europe, is a very important moment for us, because that's the moment when we have to understand that sometimes we are taking the IT actions which are extraordinary. And we first of all have to remember that they are extraordinary. So it means this is not something normal that should stay with us. This kind of surveillance is legal and is allowed by the General Data Protection Regulation at the times of the special cross-border danger to health which exists in Europe as it is at the moment. GDPR, General Data Protection Regulation, exactly says about a situation like that. But we have to know that first, this is a temporary solution, so it has to have the sunset clause. We have to know what we will do with this data, what we will do with this application and all these tracking systems once the problem is solved or once we go out of the crisis that we have. Secondly, we have to know what purposes we are using this data for. So only fighting COVID. Then we have to know who has an access to this data. Only those who are fighting with COVID. It should not be used for any other purposes, even for law enforcement purposes, even for security purposes. And finally, we have to know how we supervise that, how we have the oversight of that. That's, of course, the role of Mr. PÉTERFALVI as the Data Protection Commissioner in Hungary. That's, of course, the role of the health authorities and those who are controlling the health authorities. But this is also the role of the courts. And we have to stress this role of the courts. because we have examples in European Union and outside of European Union where courts had a lot of doubts about the way these applications are used, or the special powers of the entities at the times of the COVID crisis are used. It was like that in Israel, where Shin Bet has been stopped with activity with the application by the Supreme Court of Israel. That was in Slovakia, where Slovak Supreme Court said that the government has no right to introduce such solutions without the precise law that is required by the Slovak constitution. So first of all, the way we use it, the way we oversight that, but also the way we present it to the public. And that's the last thing to mention here. So the role of the civic society, the role of the citizens themselves to observe how these applications are created, how they are used, and what they are used for is also an important thing. And I'm also very happy that many of the international NGOs that were dealing with the subject, these are the NGOs where Hungarians are very active.
Thank you so much. I also wanted to pose you a couple of questions related to how artificial intelligence is used in this respect, but you just threw a couple of key expressions, key words or key thoughts that I would like to ask from Mr. Attila PÉTERFALVI as well. So Attila, let me pass it on to you. How is the situation in Hungary? Are there any particular national regulations that we have? Are there any particular national means that we have for contact tracing? And how is the regulation supporting that?
Good afternoon. Hi, Wojciech. Welcome in this panel.
Hello.
In the fight against the pandemic, governments and private actors are turning towards the use of new data protection solutions, new digital solutions. And in this situation, the data protection supervisory authorities have a special responsibility because we have to help in introducing these new digital solutions. But on the other hand, the supervisory authorities control these new digital solutions. I think I have to very briefly describe the Hungarian legal background. In normal situation, a constitutional right, according to the basic law, like the right to the protection of personal data, can be restricted by parliamentary act. But in spring, in the first phase of the fight against the pandemic, Hungary introduced a special situation, a state of emergency. It means that in the case on behalf of the parliament, the government is empowered to make the necessary legislations through government decrees. It means that according the GDPR and under the law of the Hungarian Data Protection Act, the data protection supervisory authorities have to make opinion about all the draft legislations. More or less, more than 90% of the draft governmental decrees was sent to the supervisory authority to make opinion. Sometimes we had to do it within a few hours. In the fight, in the first phase, I have to mention two applications. The first application was the Virus Radar application in Hungary, but this application is not a Hungarian developer application. The aim of this software is a contact tracing function. The data controller of this virus radar is the National Center for Public Health, and the legal base of this data process is the freely given consent. The time limitation is 14 days. This application uses anonymized data, but not geolocation data. This application uses only the Bluetooth technology of the device. The purpose of the virus radar is to send a message to those users who have been within a distance of 2 meters for at least 20 minutes of a COVID-positive person. But the problem is that less than 100,000 users have downloaded this application, and according to experts, the application would work effectively if at least 2 million users downloaded it. And the other problem is that the effectiveness depends on whether users upload their COVID plus test result or not. I have to mention that this application doesn't need any special legal regulation. The General Data Protection Regulation is the legal background of this application, so it has to comply with all the principles and rules of the General Data Protection Regulation. That was the first application. Maybe later I can mention the other, the second application which was introduced by government legislation. That was and is, because it's still working, the home quarantine system application.
Thank you very much. Do we know exactly what happens to the data stored and processed in the virus radar application? Do we know that?
In Hungary, the supervisory authority conducting proceeding in connection with this application, we control the privacy impact assessment of this software. So we do not have enough information. That was a question that who is the data controller. That's why I mentioned that it is important that the National Center for Public Health is the data controller, but we have to control the software, and we have to control the privacy impact assessment to say more or to give more information in connection with this application.
Great. This kind of gives me the feeling that we are not exactly aware of what happens to our personal data that we upload to this virus radar and virus radar-like applications. Never mind, I'm turning to our technical expert, Mr. Gergő GYEBNÁR, and the first question to you is like, how does the tech community see the questions of these contact tracing apps? Are these okay?
Appreciate to be here. Good afternoon. These connection tracing apps could be based on a bunch of technologies. It could be based on GSM, GPS, Wi-Fi, or Bluetooth. The Bluetooth option could be the best one of the best one, because perhaps the least surveillance friendly. Its protection is also not professional, but the best choice for this kind of application. If there is another technology called DP3T, it's research and you can find it in GitHub, and it's also based on Bluetooth technology, and but with the privacy concern developed from the Swiss government, the Swiss healthcare agency. I'm not sure about that. And these kind of technologies are using just special encrypted keys. So these Bluetooth connection allow you a wireless transmission with what could be running on the background and drainlessly do not drain your battery excessively, what is absolutely a good thing. If we are think about that, how is effectively that, how it is spread to 20,000 people download it in Hungary, what is not so much, and
so we don't really have a massive crowd that may use it. Is it possible to gain any results, any benefits of such a low use of a virus radar-like application in general?
This kind of UIDs are stored in your devices. So there is two concepts, a centralized one and a decentralized one. This virus radar its concept is a decentralized one, what means that there is no transmission to a government server. It's stored in your own mobile device. And it's such a good thing. And if you upload that you're positive, you have a positive test, then the national agency have a cryptographic key to decrypt it, and then it's send a note to contacts where you were contacted before.
Thank you. A slightly different approach that I also wanted to discuss within this panel, and that's artificial intelligence. Mr. WIEWIÓROWSKI, my question goes back to you again. This is a question I wanted to pose originally to you first, but then we started talking about what's the national government-related approach to using these applications. So now it's time to get back to artificial intelligence. What's the EU approach, or what's your approach as a supervisor to the use of the artificial intelligence in relation to collecting and processing private individuals' data? How do you see this?
That's very, very general and big topic, because artificial intelligence may mean different things. We are actually using the notion, which is a marketing notion, that is not exactly what we can call the technology. We can say that there is a set of different solutions which are called artificially intelligent, although none of them is actually the intelligence in the meaning that we usually use. Anyway, there is a group of the technologies which are used for that. As I said, it's a marketing notion, which also means that we hear it much more often than we should, because most of the entities, or rather information systems, that are called to be artificially intelligent are actually the rule-based systems. So they are of course based on different kind of algorithms, but algorithm is once again very, very broad subject. So if you ask me what is my attitude to use of artificial intelligence, this is like to all the other technologies. So the law should be technology neutral. The implementation of the legal act should be also technologically neutral. So there is nothing like forbidden artificial intelligence or allowed artificial intelligence. We simply have to take care on the results and also the way that we are achieving the results. If we are confronted with something which is a black box, meaning we don't know how the data is processed and we don't know how the results is achieved, I will definitely have a lot of doubts. As a data protection commissioner, I would be devoted to the so-called purpose limitation principle. So purpose limitation means I collect only these data that I can use for my purposes, which I know from the very beginning. Combined with the minimization principle, it should mean that I'm not collecting anything just in case it will be useful in the future, but I use it for the precisely known procedures. And of course, there is some kind of a clash or maybe a challenge in the fact that many of the so-called artificially intelligent technologies are based on the number of algorithms which in different way reuse the results of the previous operation that was developed. So when I heard, for example, during the COVID crisis, that some of the solutions which are proposed are the solutions which are artificially intelligent, from the very beginning, I had the doubts if we really use something that we know, or we are just trying to justify ourselves by saying this is not the human intelligence, that the computer intelligence or artificial intelligence which is in use. Transparency is an extremely important thing. I like your question, what happens with the data? And I know that it's not easy to answer how the data is used. But if we use some extraordinary powers to fight with extraordinary danger to our society, we should be really careful about the way we process the resource which the personal data is. So, fortunately, not too many solutions that were proposed were based on the really artificially intelligent solutions. Most of them were actually very basic. That was not the applications that were proposed for the market in Europe, for example, for contract tracing, were not very sophisticated. There were a lot of solutions in use. There were a lot of privacy concerns which had to be mitigated, but in fact, technologically, it was not very difficult. What is a challenge, and that's the really challenge for the artificial intelligence in the most common way of understanding that, is the scientific researches which are done on the data which is collected during the pandemic crisis. That's something that the data protection authorities have to deal with as well. So we have to help those who try to do the researches in order to fight with the pandemics, but also in order generally to take care of the health of the society, to use the new technologies in order to reuse the data collected during the pandemics.
Yeah, thank you very much. Thank you for mentioning this. I quite agree with the statement that you made that we need to help researchers. A couple of days ago, I participated in another event where it was actually in the focus of the discussion how biological data collection and the research related to that may be helped by cybersecurity means and digitalized means in general. So I think it's also a hot topic. But before we turn to that, I believe I can pose the same question to Mr. PÉTERFALVI about artificial intelligence. Do we have in Hungary a kind of purpose limitation kind of approach to the use of artificial intelligence for such means like contact tracing? So do we have a limitation on how data may be used in general?
I fully agree with Wojciech. So now I want to say that in Hungary, the Data Protection Supervisory Authority thinks that GDPR seems to be the legal background of the artificial intelligence and seems to be enough now. Maybe that later there will be special regulation for artificial intelligence, but now because the GDPR is technical neutral regulation seems to be enough. So that's why use of artificial intelligence must fit all the principles and rules of GDPR, not only the rules of data processing, but the rules of data security too. And I'd also like to mention that transparency is one of the most important principles of artificial intelligence. So we have to have enough information about the whole procedure of this data processing.
Thank you very much.
And one sentence, we made opinion about the Hungarian artificial intelligence strategy in this year, and we, I think our opinion was adopted in the strategy, and we said the same, that so I think we supported this strategy.
I believe what you are mentioning is the Artificial Intelligence Coalition that was formulated last year and their work.
Yeah.
Is that the one? Mm-hmm. Thank you very much. Now, a similar question, or almost same question, goes to the technical community representative. The two data protection experts mentioned purpose limitation quite rightfully with emphasis, let's say. And my question is it really applicable from technical perspective?
It is. There is, how I mentioned before, two concepts, the centralized and the decentralized one. In the decentralized aspect, basically the devices, each one teach one, so there is not a data, but it could be a vector, an attributing for a higher perspective. In the centralized way, we have a bunch of data, and we can use machine learning technologies. This machine learning is not a science fiction, it's not a rocket science, it's a if-else functions in libraries, and where we define rules, and we run against our data, and we generate a hypothesis what we would like to validate. And it's an example for spatial econometrics. Nearly the same, but on that research field, we would like to validate only one hypothesis, and in this not, we would like to validate a bunch. On the cybersecurity perspective, it's an ironic thing that regarding the COVID tracing apps, that we are looking for malware, a machine virus, due to a human virus. And the beautiful thing that we can use nearly the same technologies regarding the machine learning in the field of human virus and the machine virus as well, because of the attributes, the vectors, and the data, because the data is such a sophisticated. For example, there is a neural network in usage for mammography, for cancer research. A neural network is modeled from a dog's brain, and it's such a good thing, and the accuracy is kind of 97%, more than 97%, what is a very good thing. But if we would like to implement to our intrusion detection system, the dog in the production environment will say that not let any packet in or out. Another thing, the Indonesian government has developed a COVID tracing, not a COVID tracing app, a COVID medicine man, if I can say that. And he asks you a couple of questions. It's basically an expert system. Expert systems is intended to act like an expert human being. So if there is a question, or you feel throat pain, etc., etc., and when you answer the question, he suggest you that stay at home because these symptoms look like that you are maybe positive for COVID. And it's also machine learning usage, but another aspect from expert system, and it's not tracing, basically it's tracing nothing. So it's beautiful.
Yes, that is a positive use, let's say, of artificial intelligence within the COVID-19 scene, let's say. That's very important to mention as well, that you may have the impression that we want to stigmatize artificial intelligence because we are mentioning it in a negative sense when it comes to COVID-19 applications, how they use it, without the private individuals letting know how their data is used properly. The other hand, what was expressed by Gergő is also very important, that this is also a mean to use for positive purposes. So I don't want to be biased on this. On the other hand, which is a slightly different topic, still belongs to our panel, there is a special poll going on in the background. You may have downloaded the application through which you can make your votes. And the question that we are having on the screen for us to discuss is, who do you think should have access to data collected by contact tracing apps? And there are certain votes that you already made, and the first, I think we have like 64% saying only the users should see information regarding themselves. So, my question goes to you as well, and also to my panelists, that what's the sense? Why should we use it then, if it's only the user who should see the information? In this particular case, what do you think? Why should anyone see that? That's the question. If no one else sees that, how can you do contact tracing? Shouldn't the authority have the right to see the data? Attila, what's your approach on this?
It depends. That's why I mentioned that what is the legal base of this application. Because if the legal base of using this application, the freely given consent, it's the legal base of the public interest, which is an obligatory data processing. So when the authorities get information, I think the fight against the pandemic, national special legislation is needed. That's why I mentioned that in Hungary there was no special regulation, and there is not yet. So that's why there is no contact tracing application is working in Hungary.
If I can,
please.
If I can go here, well, despite I'm a lawyer, I would go out of my legal profession and start to think about the organization, actually, of all this action. In the perfect world, I would agree that this is only the person who should see his or her own data. If the person knows how this system operates, if he or she knows what data was collected for which purposes, and how to assess these results that were given to him or her. In such a perfect situation, I would say yes, it can be done only with the knowledge of such a prosumer, I may say, so consumer who is at the same time proactive in his actions. But of course, the world is not perfect, But the answer is not that the authorities should see it. The fact that somebody is the authority does not mean anything. What means here is the knowledge of what to do with this data in order to fight with pandemics. So usually these are not the authorities, but the specialist in epidemiology who has to have an access to this data, and those who are serving them. So if we may think of any kind of authority, that's probably the health authority of the country that may have an access to such a data, not necessarily in the identified form. It can be pseudonymized, which is still a personal data, but pseudonymized, which does not reveal the identity of the person, but allows to send an information to those who had the contact with him or her. So we have the data of the person. We don't know who is this person, but we know that this is the person who had the contact with such a infected person. So there is no one clear answer. We have to case by case check what is the reason for which the person or the institution or the authority or the organization has an access to, and somehow assess it. And it should be assessed ex ante, so before the access has been given, but also ex post. So what this person, what this institution did with this data. So not only the person, also those who are fighting with this crisis. At the same time, the very important thing is how long we are keeping this data, because there is no reason to keep the data about the identified person till the end of the world. There is some retention period after which the data should be erased or anonymized. So these are the questions that should be answered from the very beginning to the very end of processing of the personal data.
Thank you very much. I think you mentioned two extremely important concepts. One is that the data needs to the procession of data needs to be linked to purpose. And the second one is the right to be forgotten, right? I will ask this question from Attila, so I will have a question related to this, but before that I have to turn to our technology expert. And the question is that, do these applications that we are talking about guarantee the right to be forgotten and also the purposeful handling of the information that we have uploaded in them?
The right of forgotten, we can trust in that. But there are two other questions. What is important? Which kind of data they use and when this data is used. Basically, for example, a decentralized one that we have encrypted unified identifier with a Bluetooth connection that I have a connection with you, and you. And if I upload my positive test, the agency have the key to resolve that. And this is the most important thing, that they have every information about me. They just get the most important that I'm positive, but they don't know even that what is the connection map, connection graph for me, because the application do this for me and node the connected people directly, and it's not from the cloud, not from the server.
Mm-hmm. Okay, thank you. That's the technical approach. And how does it look like legally? So, can we guarantee in Hungary, through this virus radar, that the right to be forgotten is applied and the purposeful use is applied as well?
Yes, this is the task of the National Data Protection Supervisory Authority, to control all the data processing, the purpose limitation and everything, the right to be forgotten also. But it's not an easy question because it requires not only legal knowledge but technical knowledge also, because to control the right to be forgotten is a legal and technical question too. So but the supervisory authorities have all power to control it.
Would you like to comment on this?
Yeah, because there is a chance to keep this data, because we can learn a couple of things from the past. If we are using machine learning technologies and we are do retrospective analysis or historical analysis, it can do a prediction for us, and it could support. So it's also a question that what kind of data need to be forgotten and what kind of data have a usage without the impact for the user.
Exactly. We got a question from the audience that I'm sort of transforming to you, which says, are there guarantees that the special data collection measures are going to be used for the COVID crisis-related data? And my question is that, is it possible? Do we have any additional guarantees over what we have just discussed? Because, please.
I think, as I mentioned before, the authority has all the power to control it. So it doesn't need any special guarantee. Special guarantee is needed in the legislation, that the legislation is valid or can use till the end of the pandemic, and this is the requirement of the authority when we make opinion about the legislation that automatically has finished the data processing and must delete all the data in connection with the pandemic till the end of the pandemic.
So we have the legal framework that sort of guarantees that, at least from legal perspective, the data that is collected in relation to COVID-19 will be handled as it should be.
Yes, because if not, is an unlawful data processing.
How does it look like?
We have the saying among the privacy specialists that big data is the big responsibility. And the bigger the data is, the bigger is the responsibility. Not only of the controller, not only of those who are deciding about how the data is used and for which purposes, not only the people themselves, but also the authorities that are creating the law and then implementing the law. And I would just cite what the Commission, European Commission said, commenting that. That's actually Commissioner Jourova who said, the history of democracy is the permanent search of the right balance that is limiting the powers of the powerful. It is the search of the right system of checks and balances so that the citizens have their right protected and can exercise their sovereign power and as freely as possible. And this is actually what the authorities are for. This is what the Data Protection Authority is for on the national level and on the European level. And this is also what the civic society organizations are for. So that might serve as a kind of a summary of this approach. Who is responsible and who will give us the guarantee that the data will not be misused?
Thank you. Originally, I wanted to pose the last question to you, Gergő, which was about quite okay that from legal perspective, it's basically the role of the authority to guarantee that the right to be forgotten is applicable. But is it also applicable from technical perspective? A simple yes or no will do, no?
Yes.
Yes, thank you very much. Now we have only a little bit more than 1 minute left for the panel. So I kindly ask you to tell us, all the panelists, I kindly ask you to tell us one key takeaway that you would give to our audience.
The privacy proved to be one of the most important the most important lens which we look at the solutions at the time of the big global crisis that we had last year.
Thank you.
I'd like to add that the GDPR is the applicable law in the fight against pandemic, so we must apply GDPR.
Thank you.
Change your mind and install this kind of application, because it is for the human race, and it's not to surveillance you. And if you are put in contact that you are using a home assistant and you allow an instant wiretap in your home, and this is absolutely agreed. And on the other hand, this application, what is for the bigger one.
Thank you. Thank you very much, gentlemen. I truly enjoyed discussing this topic with you, so thank you for your cooperation and collaboration on this. And I also hope that we gave some thoughts to the audience to follow up on. Thank you. Enjoy the rest of the afternoon.